Ibrahim, and this is Kivumbi2017 right here on KTN News. And a few minutes ago, the Supreme Court, the highest court in the land, made several rulings with regards to several applications that have been made, by various parties who are interested in that case. There are those who want to be enjoined in that case, as amicus curiae, among them the Attorney General, the LSK, Lawyer Charles Kanjama, as well as the ICT Association. Of course, the court there dismissed some of those applications and accepted others. We're going to join our Sophia Onuna shortly, who's still on standby for us at the Supreme Court of Kenya. But before that, let's go straight to our headlines tonight. Supreme Court delivers its rulings on applications made by the petitioner and respondents in presidential election petition. James Orengo to lead 6-hour NASA legal argument as Supreme Court starts petition hearing Monday morning.
Ban of plastic, use of plastic is something that will help or will go a long way to ensure that our dream or our objective as far as conservation is concerned is achieved. Convenient today, illegal tomorrow morning. We bring you diverse views of citizens ahead of Monday's plastic bags ban. And flames of fury as border riders torch a car in Nyeri over claims it hit a fellow rider. Welcome back once again. If you're just joining us, the program begins right now. My name is Yusuf Ibrahim. Let's now cross over live to the Supreme Court of Kenya, where Sophia Onuna is on standby. Now, Sophia, good evening. The court there have made their ruling with regards to, those applications that have been filed. I saw you speaking to some lawyers there. How did they receive the ruling? I'm sure they have some sort of mixed reaction towards it.
Indeed, mixed reactions, but largely just accepting what the judges here at the Supreme Court have ruled this evening. Let's start by quickly running through the rulings that have been delivered this evening. And we begin with those that were seeking to be enjoined as friends of the court, seeking to help the court with information that has bearing on the case. The Attorney General has been granted his request. However, it has been limited on in terms of the capacity or the area in which he can be able to address the court in, and the judges in delivering that ruling said they have discretion to guide the Attorney General, and they're limiting him in regard especially to a case that was before the Court of Appeal, IBC versus Maina Kiai, which specifically went into the question of the final result being from the constituency level. So that is where he'll be allowed by the court to address the judges on. And then the Law Society of Kenya as well have been granted permission to join the petition. However, as well, their participation being limited, and it's really about conduct of elections and how that should happen in a verifiable, free, fair, credible fashion. Two other amicus curiae applications, however, have been dismissed. Charles Kanjama, we spoke to him earlier. He was disappointed, and remember, all the parties were against his application to be amicus curiae, as we had the judges note as they delivered that ruling. However, he says it's regrettable because he's also the chairman of the Law Society of Kenya Nairobi branch. So he says just because the Law Society of Kenya is an amicus, it doesn't mean any of the lawyers around the country should not be admitted if they sought to do so, and especially if they presented evidence that they have expertise in various areas. However, that expertise which he talked about, the judges were not in agreement with, and they threw his application out. Also, another application that was kicked out was of the ICT Association. Remember, there's that crucial question about technology. In fact, the petitioner is seeking to look into the servers and the logs. However, they also were unsuccessful. Then the other four applications were those as interested parties. Michael Wainaina is successful, and he has been able to be granted permission to join as an interested party. But before I give you more information on what transpired tonight, because my guest is about to leave, let me speak to Kakai Kissinger, who is a former Deputy Chief Registrar of the Judiciary, on some of what we've seen unfold. And then we can engage later, Yusuf, on what else the judges have ruled on tonight. And thank you so much, Kissinger, for joining us. Let's begin with generally what you made of those rulings you had tonight.
I think when you look at the rulings, they were very well reasoned and very, very fair because the court is very concerned of what happened in 2013. So they are trying, first of all, to right the mistakes of 2013. One of the key mistakes of 2013 was to rely on issues of the technicalities. And you remember in 2013, some documents were expunged from record because of the technicalities. Now we are seeing that they are running away from that issue of technicality, and most of the documents have been submitted or agreed and running away from technicality. So that's a very, very good thing in terms of running away from technicality, so that in the spirit of justice, everyone is on board and everyone is given an opportunity to listen to those documents. The other key thing is that the court is constrained of time. There are a lot of time limits because they only have 6 days up to Friday to finish the ruling, and they're running out of time. And what you have seen is that they have limited the issues of friends of the court. Amicus curiae have been limited, and they're being given just one issue to discuss. For example, the Attorney General has only been given an issue to discuss on the minor Kiai case, and the LSK has been given an issue to discuss on the Elections Act, Section 83 of the Election Act, which deals with issues of how fair an electoral process can be and whether law was followed, and if it was not followed, how can it then an election be null and void. So you can imagine that the court is aware. And then interested parties have been given also a role, but limited. So it's a very fair judgment. The only thing which is pending as of now is the issues that were canvassed yesterday, the issue of how NASA or the petitioners can be given an opportunity to go into the system and have a look at it. And I guess the judges are still consolidating their views and agreeing, and I hope that by tomorrow, as they have promised, they should be able to give a judgment on that.
Yeah, and quick one on that, because it was a unanimous decision on by all the judges on all the other applications. On this one, they are yet to rule. Does it speak to perhaps the judges not being unanimous in reaching an agreement on whether to allow the petitioner to get into the IBC servers?
No, you see, when you look at the judgment that have been given, all of them today, it's a unanimous judgment, meaning that they have agreed, they have conference, and they have agreed, and they have given a judgment which is sound and solid, and all of them agree. So the possibility is that probably they are still agreeing and trying to come up with a very solid judgment.
But perhaps today they disagreed.
Yes, exactly. Maybe they disagreed, but all I can tell is that they are going to come up with a very solid judgment, and it will be unanimous.
Yeah. Let's talk about the issues that will actually come before the court for determination. The last time they were clear before the hearing began. This time around, the parties were unable to agree. The judges have said they will not decide for the parties. So it means going forward...
Going forward, I think they were given a chance. The parties were given a chance to agree on issues. They didn't frame the issues. They didn't agree for issues yesterday. The registrar of the Supreme Court couldn't agree with the parties. And then the parties surrendered the issues to be discussed or canvassed by the court. And we are hoping that some of these things by tomorrow, they will have been clarified so that issues will be clear. We know how many issues are on trial. And then they will be restricted in terms of analyzing and discussing those issues as agreed by the court. So that's something that I'm sure tomorrow will be clarity.
Yes. And the question of time, it clearly is the thorn in the flesh, not only of the judges, but of all the parties involved. And we've talked to some of the counsel as they were leaving, and it's various views. There are those who think we need a review of that, have a longer period of time to go through this petition. Some think it's okay. What are your thoughts?
The 14 days that we have in the law, it did not come from the sky. The 14 days came from the Kenyans. If you do recall the Guy Commission, the Guy-led Constitutional Review Commission, it was talking about 7 days. When you saw the Constitution mutating to Kilifi and finally Boma's draft, it changed to 14 days. So we are stuck with the 14 days, and judges have to just work with the 14 days. There's nothing they can do about it, and this is what Kenyans wanted. Kenyans wanted 14 days.
All right. So when, of course, the hearings begin tomorrow, we've had the timelines that each party has been given. It is largely that we'll expect a comprehensive written judgment from what the Deputy CJ mentioned yesterday. The timelines, because the last time you were following that petition, you were in office at the time, and they were unable to write a judgment because of the time constraints.
The time constraints will continue being an issue, and we hope that one day Kenyans will rethink about the issue of the timelines and change it through the Constitution. But that remains a dream, but it's a reform that Kenyans have to think about. In terms of the deadlines to write the judgment, it's unfortunate, but the judges are going to work overnight. They will work very hard to ensure that they come to it. Now, the issue then is quality and quantity. That's now an issue for the bench to discuss about, but they must write the judgment. But then the law doesn't restrict them to write individual judgments. They can write a unanimous judgment or they can write a dissent judgment, whatever the case it is. But then it always is a challenge. But I'm telling you, you have a good bench. They will be able to do justice to this petition.
All right. Many thanks, Kakai Kissinger.
Thank you so much
for joining us here on KTN News. Kakai Kissinger, who was former Deputy Chief Registrar of the Judiciary, talking to us about his thoughts on what we've had this evening from the Supreme Court. So, Yusuf, as we ran you through that, what is clear is that the judges have decided on this particular other interlocutory applications that had come before them that were on questions of documents, affidavits being filed out of time. All those have been kicked out, whether it's the petitioner who filed. Remember, they'd asked for the written submissions to be stricken out. But the court has ruled if that happens, then the entire petition collapses because then the respondents do not have a say in the petition. Of course, as well as the first respondent, the second respondent, the third respondent, all of those applications they'd made around striking out of documents because of the question of being out of time, all have been disallowed, Yusuf.
Sophia, before I release you, clearly you've had a long day at the Supreme Court, and of course we need your extensive coverage tomorrow when that proper hearing begins. From my observation here, it seems the petitioners were dismissing, applications from everyone. And I saw you speaking to James Arango earlier. Is this some sort of a strategy they're deploying? It seems they don't want anyone to bother them. What were they saying?
Please come again, Yusuf. I didn't catch the question.
Well, from the observation that we've made from this end, Sophia, it seems that the petitioners were dismissing all these applications from almost everyone. Is this some sort of strategy they're trying to deploy? I saw you speaking to James Orengo earlier. What was he saying?
In terms of the applications that had been made, for example, the application for the Attorney General, who now is going to be a friend of the court, they had objected, and their argument is that they do not see him as a person who brings a bipartisan assistance to the court. They see him as a partisan party, if you like. Some even in NASA have argued, as opposed to being a friend of the court, he's more a friend of the government. But those are just aspersions that have been cast outside the courtroom. What matters tonight is that the judges have spoken. They have ruled on these particular matters, and now we have the Attorney General as amicus curiae. We also have the Law Society of Kenya. As we said there earlier, they are limited in as far as their presentations and the scope with which they can engage the judges with, and as well as the interested parties, those two former presidential candidates in the just concluded general elections, Kuru Okot as well as Michael Wainaina, being the only two interested parties being allowed to be enjoined in the petition. They each will have 20 minutes to address the court. Remember, Michael Wainaina's argument or really pursuit to be enjoined in this particular petition is in support of the arguments by the respondents. In essence, he says that the 8th August general election was conducted free, fair, and in a credible manner. However, Ekuru Court, his argument sides with that of the petitioner. He wants the same election nullified, the results nullified. So those are some of the key highlights. But tomorrow is crucial. We spoke to various counsel. They were non-committal on what their thoughts are, rightfully so, because it is a matter before court, on why the judges did not give a decision on that application by the National Super Alliance, by the petitioner Raila Odinga, as well as the second petitioner, Kalonzo Musyoka, with their request to look into the service and the logs of the IEBC. So for that one, we'll have to wait until tomorrow morning when the judges will direct on the same. But keeping in mind, if they do, the question of time continues to come up in each and every aspect of this particular case. But Yusuf, from early morning tomorrow, our various teams, great teams here on KTN News, will be covering these hearings as they begin throughout to the very end. And remember, to all our viewers, the decision that will be coming out from the Supreme Court is the last word on this election.
Many thanks, Sophia, for that update. Of course, we're looking forward to link up with you tomorrow morning with that proper hearing. It's going to begin at the Supreme Court. And a few minutes ago, as Sophia has explained there, the Supreme Court, that is the highest court in the land, made a ruling with regards to several applications that have been, filed by several parties who wanted, to be enjoined in that case, that those who want to be enjoined as amicus curiae, that is friends of the court, and they include lawyer Charles Kanjama, whose application was dismissed. They include the Law Society of Kenya, whose application was accepted. The application by the Attorney General, Professor Kivumbi2017, was also accepted, and the application by the ICT Association was also dismissed. So let's listen in to some of the judges there making that ruling a few minutes ago.
You are seeking by your application to join this petition as an interested party. The court, in unanimity, has considered your application, and the court is of the view that your application lacks merit, and it dismissed without any orders to costs. Thank you.
Thank you. Next, Judge Njoki.
This is the application of Mr. Michael Wainaina Mwaura, who seeks joinder in the capacity of intended respondent or amicus curiae. This court, having looked at the law which we have laid out and principles concerning an amicus brief, we find that the applicant does not meet the criteria set out in law to be amicus, and his application for that fails. However, having looked at the record, we find that the applicant meets the conditions set out in law on joinder to interested parties to a suit, having been a candidate in the just concluded general elections, and has shown a personal stake in the matter. We therefore state that the application is allowed, and we order that the applicants has written submissions to be filed by 8 in the morning by the 28th of August, that is tomorrow. Those submissions should be limited to 5 pages only, of not more than font 12 with 1.5 spacing. The next application is by the intended interested party, Ekuru Aukot. Again, as the court, we have looked at the law. We have found that Mr. Aukot, as a presidential candidate in the election of 8th August, has an identifiable stake in the matter, and he will be directly affected by the outcome of this petition. His application is therefore allowed. He is to file the alleged report in his affidavit by 8 a.m. tomorrow and serve upon all parties. He also must file his written submissions, again limited to 5 pages only, of not more than font 12 and 1.5 line spacing.
Well, those are just some of the judges, the form of the 7-judge bench of the Supreme Court. They're giving their ruling a while ago. Now, the hearing of the presidential election petition is now set to begin tomorrow at 9 a.m. Now, James Orengo, who is leading a team of lawyers representing NASA Principal Raila Odinga, will have 6 hours to argue the case challenging the re-election of President Uhuru Kenyatta during the August 8th polls. Rita Tinina now reports.
9 days after NASA Principal Raila Odinga filed his petition challenging the re-election of President Uhuru Kenyatta, the 7 judges of the highest court in the land are set to handle one of the most crucial and anticipated petitions on the Kenyan political scene.
I want to seek your indulgence, all of you, that when we start, first and foremost, let us have respect for each other. Absolute respect for each other. Let us conduct these proceedings soberly.
With a team of more than a dozen lawyers led by James Orengo, Raila's legal team will have 6 hours to argue its case.
Then this court will be able to verify whether that election was transparent, credible, and accountable.
NASA filed a 25,000-page petition and outlined 28 issues it wants determined by the court in a case with 3 respondents, the IEBC chairman Wafula Chebukati and President Uhuru Kenyatta.
The application we have made, that is the first and the second respondent, to strike out 3 volumes filed by the petitioner. Those 3 volumes relate to evidence, additional evidence, filed outside the constitutional limit of 14 days.
The third respondent filed a motion seeking to strike out certain pleadings filed by the petitioner.
Yes.
The application has been responded to. We are ready and able to make very brief submissions in respect to that motion.
In the petitioner's list of issues, NASA is questioning, among other things, whether the presidential results on the IEBC portal reflect the actual results in Forms 34A and 34B at the time of announcement of results, whether the results show any results from ungazetted polling stations or tallying centers, which were the specific polling stations affected by the 3G or 4G network coverage, whether all the Forms 34B used in the election were similar for every constituency tallying center in design, form and format, and whether the returns showed results signed by ungazetted returning officers.
Form 34As are brought before the court and 34Bs together with the transactions through transmission that were done electronically. If they are brought before this court, then this court will be able to verify whether that election was transparent, credible, and accountable.
The IEBC has listed 2 issues it wants addressed: whether President Uhuru Kenyatta was validly elected and declared the winner, and the reliefs to be granted by the highest court in the land. Uhuru Kenyatta, through his lawyers, has listed 5 issues, among them whether the elections were conducted in accordance with the Constitution and the Elections Act.
We will not adjourn.
The issues raised by the petitioner and the respondents will form the basis of the deliberations before the Supreme Court gives its verdict on whether to uphold or invalidate President Uhuru Kenyatta's re-election. Rita Tidina, KTN News.
Many thanks, Rita Tindina, for that report at a time when the Kenyan presidential election has now officially moved from a political battle to a legal battle, or some sort of legal battle of minds, as you've seen there from the proceedings at the Supreme Court. Kivumbi2017 takes a very short break, but we'll be right back with much more stories still on the presidential petition. Don't go too far. We'll be right back.
This is KTN News.
I like to call Flex the mother of all bundles. Juu with Flex, unaweza tumia bundle moja kubrowse, kucall ama kutuma SMS.
Mawaidha ya biashara yanaletwa kwako na Safaricom Flex.
Unongoja? Dial *100# or *200# to join Flex today. Ile bundle flexible na affordable na kukupea rewards every time you use M-Pesa. Switch to Flex. Get more, use everything.
From the county of Nyeri, I am Carol Nderi, and this is KTN News.
You can take up position, but if you can't deliver, you can take up, yes, and earn. I don't believe in that. The teachers would have been very enthusiastic to see me in Parliament. The workers are very enthusiastic to really see me in Parliament and to see one of their own representing them, specifically in Parliament. But this became humanly impossible on analyzing the ability.
This is KTN News.
Welcome back to the program. This is Kivumbi2017 right here on KTN News on a day. Just a few minutes ago, the judges at the Supreme Court made rulings with regards to several applications that have been made by various parties who wanted to be enjoined in the presidential petition. Among those applications have been accepted include the Attorney General, the Law Society of Kenya, presidential candidate Ekuru Aukot, as well as Patrick Wainaina, whose application in the earliest stages, the judges had mentioned that he did not meet the criteria as amicus, but later on his application was allowed. Of course, we are still here making sure that you don't miss anything as far as the Supreme or the presidential petition is concerned. Now, the Supreme Court yesterday began hearing the NAS's presidential petition in a session marked with intense legal arguments and strict directions from the 7-judge bench. But just why did the judges prefer the red and black robes as opposed to the green gowns with gold stripes adopted by retired Chief Justice Willy Mutunga? Political affairs reporter Murimi Mwangi explores that aspect and files the following story for us. Take a look.
On a day like today 7 years ago, this was the sea of humanity that flocked to Uhuru Park to witness the rebirth of Kenya through this document. The 2010 Constitution that subsequently gave birth to the Supreme Court, and perhaps in symbolism of the momentous journey to this day. The first man at the helm of the apex court, retired Chief Justice Willy Mutunga, announced some radical changes in the judges' dress code. First, by getting rid of these white wigs and red robes, which had over the years defined the image of the Kenyan judiciary.
Chief Justice is no longer a judicial monarch who carries a huge rungu, is actually a dictator, can transfer people, can do all kind of stuff. It's been decentralized.
At the Supreme Court, Mutunga introduced these green robes with gold stripes as the official dress code for judges. A new look that was followed by a circular in which Mutunga discouraged lawyers from addressing judges as my lord or my lady, instead placing preference for such titles as your honor or mheshimiwa. But this did not go down well with some of the learned friends.
If you interrogate that regalia seriously, it has a lot of borrowing from the United States. And maybe that will explain why it was associated with Mutunga, because Mutunga, during his time in exile, had associated himself so much with the system in the United States.
Some of the reform signals were the attire, because what the judges had been wearing before reeked of colonial hangovers.
Mutunga retired on the 16th of June 2016, but the signs that it was not going to be business as usual at the Apex Court became evident exactly 4 months and 3 days later.
David Kenani Maraga,
as his successor, Chief Justice David Maraga, took oath of office on the 19th of October last year, dressed in this attire.
It is quite evident that he wanted to restore the dignity of the court as known within the Commonwealth, where the manner in which a judge is dressed, and in actual fact that gown is called a dress, the manner in which a judge is dressed signifies how serious the issue is.
And at the pre-trial conference of the NASA presidential poll petition at the Supreme Court, the second in just 4 years, red, black, and white were the new colors on the Apex Court bench. Colors and attires which legal practitioners argue bear great symbolism to the seriousness of the matter at hand.
Black symbolizes a somber moment, that you need to be silent. There is business of the court going on. Now, scarlet initially symbolized danger, but in the legal palace, it symbolizes the fact of finality of what is about to happen.
It's kind of restoring faith among judicial operators, experienced judicial operators, that things are normal or proper as they should be, but not the way they used to be. So you can see that even the uniform is different from what it used to be and what Mutunga's uniform was. So this is the Maraga stamp.
Some observers argue this attire bore immense symbolism to the slight change in rules of engagement between the bench and the bar.
The judges are also human. We cannot expect you to spend the whole day listening to submissions by counsel and then go and spend the night writing the judgment.
Do not have mercy on us. We haven't been sleeping the last few days and we are still okay. And since we are not complaining ourselves, we are mindful that we must finish this matter within 14 days.
As the Friday deadline for a verdict in the NASA dispute approaches, the 7-judge bench will no doubt remain on the spotlight as the Apex Court prepares to deliver a verdict in the second presidential poll petition under the 2010 Constitution. Muremi Mwangi, KTN News in Nairobi.
Clearly, all eyes are literally on the Supreme Court judges. Many thanks, Murimi Mwangi, for that interesting story. Now, top politicians from Jubilee and NASA trooped to churches in different parts of the country today as the presidential petition of the Supreme Court gets underway. NASA leader Raila Odinga attended a service at the All Saints Cathedral right here in Nairobi, while Deputy President William Ruto attended a service at Uasin Gishu. In Soy constituency, that is Uasin Gishu County. McNamara is up next with that report.
Raila Odinga today led NASA principals and legislators-elect in a church service at the All Saints Cathedral in Nairobi. And after the service, this was his message capturing the current post-election political situation in Kenya.
Most Kenyans are hurting because of what happened on the 8th of this month. And Kenyans are crying for justice.
Raila, who was declared second in the presidential polls, trailing the incumbent Uhuru Kenyatta, has insisted that his presidential ambition is still on course and still equated it to the unstoppable biblical journey to Canaan by Israelites.
No force on earth will prevent the will of the people of Kenya to liberate themselves from political repression, political oppression, from corruption, from deceit, from misrule that has characterized the government of Jubilee for the last 4.5 years.
Hundreds of miles from the city in the Rift Valley area, Deputy President William Ruto of Jubilee was also in church, choosing to worship at the African Inland Church Kiborokwa, Soy constituency. Ruto hailing the electoral process as a success.
Ilikuwa ni kazi ambayo ilituletea heshima kubwa katika nchi ya Kenya na nchi za nje kwa sababu ya utaratibu, kwa sababu ya demokrasia vile tulitekeleza bila ya fujo, kwa misingi ya sera na kuhakikisha kwamba tunawaleta Wakenya wote pamoja.
Ruto also called upon Kenyans to respect all constitutional institutions regardless of their political inclinations.
Ni vizuri ya kwamba hata wale ambao walikuwa na matatizo na kukubali mambo ya uchaguzi wamefuata taratibu ya katiba, wameenda kotini, kesi itafanyika, itaamuliwa. Wananchi wa Kenya tayari wameshaamua viongozi wao na Kenya itaenda mbele baada ya mambo haya ya Kenya.
The opposition NASA outfit, the ruling Jubilee Party, and the electoral body IEBC are locked in an epic legal contest at the Supreme Court, where NASA is challenging the declaration of President Uhuru Kenyatta as the winner in the just concluded election. Mark Namaswa, KTN News.
Thanks, Mark, for that report. Even as we await the hearing of the presidential election petition tomorrow morning at the Supreme Court, of course, it is a hearing that is going to take a total of about 5 days up until Friday, when we do expect the final ruling from the 7-judge bench. Something interesting is also going to take place tomorrow as well. That is the total ban of plastic bags is going to take effect tomorrow. So we'll have that story much more within this broadcast. Don't go too far. We'll be right back after this very short break.
This is KTN News.
If you want to be a lion, you must think like a lion. To outsmart the lions, you must have a killer instinct and a passion for business. It's back to feeding time in the den. Once again, budding entrepreneurs will pitch their ideas to the lions, Kenya's top business leaders, for the next big deal. KCB Lions Den Season 2 premieres Tuesday, 5th September at 8 p.m. on KTN.
Garissa, Kardasi hatutaki. Kardasi ametuletea shida. Kwa hivyo serikali ya Kenya akifunga tunamuunga mkono. Ndio. Sababu shida ya Kardasi ni mingi. Mbuzi nakula, ng'ombe nakula, bunda nakula, inaleta chafu mingi, ametuletea shida Kenya yetu hii na hasara mingi.
This is KTN News.
Welcome back to the program. This is Kivumbi2017, and let's go straight to that ban everyone has been talking about. And in just a few hours, the ban on non-biodegradable plastic bags will take effect as the Ministry of Environment seeks to implement its directive to phase them out. Kenya becomes the 11th country globally and the second in Africa to take action in support of the UN's environmental campaign. But as Caroline B. now reports, opinion on the ban remains as divided as ever.
Endless piles of rubbish line Kibra's thin lanes. Heaps of plastic bags color this impoverished corner of Nairobi. Residents go about their daily chores, unperturbed by the hazard in their sight. One rule is observed in these footpaths: avoid stepping on the plastic bags. They could be loads of human waste, commonly known as flying toilets. The readily available plastic bags have paved way for this situation.
I don't see if it will really take effect, because even if you look at the Nema people, the city councils, I don't think if the Nema people or the city councils knows about the informal settlements.
The good thing is the smaller percentage, but kama maisha yao wenye to specific people wanatumia flying toilet kutumia jwala, maisha yao itakuwa a bit tricky, because wajakuwa na ile maisha uzoefu wa kutoa pesa kwenda kwa choo, ama so itabidi sasa utabidi wa reduce expenses zao so that wakacalculate ya budget pia kwenda kwa choo.
For close to 3 years now, Umande Trust, an NGO located in this slum, has been the champion of innovative solutions to address the persistent sanitation problem. Since its inception, flying toilets have declined in number. Those wishing to visit the toilet pay a fee of 5 shillings. And with a looming ban on plastic bags, could this be the end of flying toilets?
To some, it won't be realistic, because unajua watu wengi huamini ya kwamba kwenda choo, especially in the informal settlements, watu wengi hawajaamini ya kwamba kwenda kwa choo mpaka alipe pesa.
Wakitoa juala itatupatia wateja wengi watakuwa wakikuja hapa, wale wenye wanatumianga flying toilet wataacha kutumia.
Kibra's market is a throb of activities. Women are hard at work packing foodstuffs for sale in clear plastic bags. Come Monday, the plastic bags will be no more. The government will make good its word of phasing them out. News that has pierced the hearts of these traders.
Sasa ni kama nitafunga kazi juu sina njia yoyote yenye nitatumia. Siwezi pimia mtu kwa mkono, na mtu hawezi beba sufuria toke nayo kwa nyumba alete kwa barabara nimpimie.
Tujui tunatumia nini, sababu wamesema kuanzia kesho hawataki majuala. Sasa tunajiuliza kama wataki majuala, hawa wanaume wanatoka kazi usiku, watakuwa wanabeba mboga namna gani?
Once the ban is implemented, penalties set in for those found in possession of the plastic material. A fine of 4 million shillings or 2 months in prison.
Sasa hiyo 4 million shillings wakinishika na hii business yangu hawezi kutoa hiyo, sababu kwa day peke yake na profit ni 100. Hiyo 4 million naweza kutoa wapi?
The Masai Mara has for years been a pride of the country, but plastic bags have left an ugly stain in the Mara's outstanding natural beauty, further affecting domestic animals that have coexisted with wildlife for decades. Locals collect the carrier bags daily, and the ban, they say, will restore the park's lost glory.
More than 80% of the waste here are actually from plastics. And we have suffered a lot as a result of the plastic being thrown everywhere around the ecosystem. So we've seen so many wildlife dying, we've seen many livestock dying as a result of that. So it's something that we've positively received, and we will definitely also help the government in terms of enforcing that law.
The ban of plastic, use of plastic, is something that will help or will go a long way to ensure that our dream or our objective as far as conservation is concerned is achieved.
Be warned, in just a few hours' time, the ban will take effect countrywide, with the government rooting for the African-crafted kiondos, among other solutions, as alternatives to end the pollution. However, poor waste management, and a mentality of littering could render the prospect of a plastic waste-free society unrealistic. Caroline B., KTN News.
Caroline B. there says in her report, be warned because that ban will take effect by midnight tonight. We just have less than 3 hours to go. Now, border operators in Gatitu village in Nyeri County set ablaze a vehicle that was allegedly involved in an accident in which one border operator lost his life. However, firefighters from the Nyeri County Fire Brigade managed to put out the flames. The owner of the vehicle also managed to escape the mob that descended on the car. Witnesses condemned the act of mob injustice by the riders while urging Kenyans to remain calm and avoid taking the law into their own hands.
Even from the insurance point of view, they may want to come and compensate the rider who was killed, but at the same time, they also want to have a say on, on the ownership of the vehicle. So what sense does it make? We need to come to common sense. We need to make common sense as Kenyans. We start rushing into these things of torching things. I think that's a thing of the past.
This is KTN News.